numbers 1 and 5 have been served. The notice addressed to respondent number 5 has been accepted by respondent number 1, which is accepted to be a valid notice. Respondents number 2, 3, 4 and 6 have not been served. You are appearing for whom?
The respondent, my lord.
You are appearing for which respondent, Mr.
All the respondents.
All right, so we need not await. I thought you are appearing only for 1 and 5. You are appearing for all of them.
All the respondents.
Look here. The office notes is ignored in view of Mr. Mrigank Mauliland, senior advocate, appearing for all the respondents. Yes.
Your Lordship. Your Lordship, the appeal is against the order dated 3/5/19, parcel C.
Mic on के mic on हो गया
18953
Yes.
of 2013, Your Lordship. Your Lordship, in this case, the Honorable Single Judge has allowed the board to charge the final cost of the flat, which comes to 3,58,800 and odds. But Your Lordship, in the entire order, Your Lordship, the Honorable Single Judge has discussed about the revised price. Your Lordship, this is a case wherein the board has charged interest on delayed payment, Your Lordship. There is nothing with respect to revised cost, because even if...
Now, which part of the order
Your Lordship.
talks about that which you have challenged?
Your Lordship.
Which
Your
part
Lordship,
of the order? It's
Your
50 pages order.
Your
You need to
Lordship.
point out
Your Lordship.
and then
Your
tell us
Lordship.
the background facts.
Your Lordship. Your Lordship, at the very outset, Your Lordship, this Honorable Court has relied on a case of this Honorable Court, which is with respect to price
What has
revision.
happened, Ms. Vinita? You need to tell us what
Your
is.
Lordship. I'll tell.
Why are
Your
you
Lordship.
aggrieved by this order?
Your
What has happened? Why
Your
did Saraswati Roy come before the court? What happened?
Lordship.
Mr. You are
Lordship.
taking advantage of this order. Tell us what is it?
My lord, initially the petitioners, Saraswati Roy and others, she is a substituted petitioner, my lord.
Yes.
Originally, the petitioner had been allotted a house on 20th of October 1984.
Yes.
Now, subsequent to that, 20th of October 1984, which is Annexure 1 at page 18, my lord.
Yes.
The father of the late petitioner Mathura Nath Roy was originally allotted that house, and subsequently he was substituted. My lord, Mathura Nath Roy was a retired judicial officer, and he had made an application for transfer of the name of the petitioner Mathura Nath Roy. The father's name was to be substituted and his name was to be added to the allotment letter. But subsequently, since it was not done...
Just a minute. Mathura Nath Roy was the original allottee.
No, my lord. Srinath Roy was the original allottee.
Srinath Roy was the original allottee.
My lord. Mathura
Then what
Nath,
happened?
and Mathura Nath Roy was the practicing advocate from this honorable court was, my lord, had made an application for substitution of his name since his father had died, and that led to a letter from the housing board in the year 1987 saying that if you pay the current price, then we will substitute your name in place of your father.
Was that the part of agreement with Srinath Roy?
No, my lord.
Is there any requirement of paying the current price over
No,
and
ma'am.
above what price has been
No.
paid for substitution of the name?
No, my lord.
So did you challenge that? No,
My
you
lord,
did not.
that was challenged
Yes,
before
then
this
what
honorable court.
No, don't. I mean, we
I'm
are not categorizing.
My lord, we
that
just
is not
giving
the
an
way I
overall
think it
view
would-
of the-
Give us
my
the overall view without my asking.
My lord.
Yes.
So, writ application 3924 of 1996 was filed,
Hmm.
and pursuant thereto, the relief that had been sought by Mathura Nath Roy was that I should be given the house and my name should be substituted in lieu of my father's name at the rate that had been described in the original allotment letter,
Then
which
what
was
happened?
just about 80,000. This honorable court took cognizance, gave them the notice, and then thereafter they agreed that they withdrew that letter of the current price, and then they agreed that we'll substitute our name in accordance with the terms and condition as has been described in the 1984 letter.
All right. Then
Thereafter, by virtue of the letter that had been issued, this writ application was withdrawn and release agreement was signed, and the installment amounts had been fixed for 793 rupees. That had to be paid in 180 installments. Those installments were paid. Now, in the meantime, what happened was, my lord, that after the installments had been paid, the Mathura Nath Roy the petitioner wrote a letter to the housing board saying that now you execute that registered lease in my favor. Now, when that letter
Which is normally done after all the installments are paid.
my lord,
Yes.
so not only 180 or 181 installments have been paid.
Hmm.
Now, thereafter, they said that an amount of about 16 lakhs of rupees tentatively is due as against you for failure to pay all the installments. We are cancelling because those installments have not been paid. We are cancelling the original lease agreement that had been executed with you.
But you say that you paid all the 118 installments.
That is where the crux of the dispute lies, my lord. They said that I have not paid all the installments.
No, that's a question which can be, that's a factual situation which can be
Lordship,
decided
may
by
I-
the
They
records.
came out with in the counter, then we filed this writ application against that order of
What was
cancelling.
the stand of the board that you had not paid how many
My lord,
installments?
at page 93, my lord,
Tell
will
us
find in
first and then
paragraph
we will
4,
refer. How
there,
many installments you had not paid?
none, my lord, all 180 installments had been paid,
There's-
181 installments had been paid.
Their stand.
Their stand was, their stand was very vague. They said installments have not been paid. In paragraph 4 of their first counter affidavit, they said installments have not been paid. Penalty have been imposed for non-payment of those installments, and then interest was charged over that non-payment of the
All right.
installment.
So you challenge that.
My lord. So we had, by virtue of this writ application, we also had on record, my lord, all the 180 receipts against all the 181
That's true.
installments.
So what happened in the writ petition?
Now, in the writ application, my lord, their contention always was that we have increased the price in the year 1998 by virtue of a decision of the housing board in April 1998 saying that the price has gone up to 3,58,000. Now, that communication was never made to me.
Just at this stage, is there an escalation clause in the original agreement?
No, my lord, all that they said, they are relying upon one word that the price was tentative.
All right. So that,
And that it could go up.
All right.
My lord.
Taking your case at the worst and their case at the highest pedestal. So it was within the agreement for a re-evaluation of the price which a lottery had to pay. Nonetheless, what happened in that writ petition when you challenged?
This is the writ application which is under challenge before my lords in LP.
Yes, who is Saraswati Roy?
my
Wife
lord,
of late Matrana.
Wife of
Wife of
Mathura.
late. Then what happened? What has the court decided?
My lord, it has decided that since there was no notice that had been given to him, and this honorable court relied upon various judgments of this honorable court, saying that in case if there is no notice to the petitioner with regard to the escalation, it was highly unreasonable because the house was constructed as in the way back in the year
That's right.
1987.
So let us not.
The
Just
court
a
has
minute.
considered that fact. my
No,
lord.
that's all right. That principle cannot be doubted that if you did not have notice and if the court puts the
Even otherwise on merits, my lord, this honorable court was pleased to observe that the house was constructed in the year 1987 itself. It was ready. The price had not been ascertained even as on 1987. There was a writ application, interstate dispute between the parties before this honorable court. That was in the year 1996. They agreed to a price as on 1984. So till that time they could not have charged any interest. Now
And their notice which you say you never received, which they say they sent it to you.
My lord.
This was in which year?
This was in the year 2007.
2007. Now ultimately when they threatened you of ejection and termination of the contract, you
My lord.
came before this court.
I came before this
With a
honorable court.
plea that you are ready to pay the entire cost but not the interest on the delayed payment.
Though we challenged, initially we had challenged everything, my lord. But subsequently the writ court had directed us that we paid 3,58,000 as had been determined by the...
Show us from the judgment which part of the order or the judgment the court has taken evidence and has decided, taken evidence in the sense that he has relied upon that material to say that you did not receive notice.
My lord. My lord will kindly come to page...
Because if this is true, if
My lord.
the court agreed and allowed the board to charge you the price, the escalated price, the enhanced price, then perhaps delayed payment issue would be dependent on facts, right?
My lord.
So where has the court decided and on what material the court has decided? These things have to be pointed out by you, MS Vinita
Your
Singh.
Lordship,
Which
that is,
paragraph, which line? Don't expect the court is expected to read all.
Your Lordship,
50
no, Your
pages,
Lordship,
but then
My lord,
page
I kindly
9.
come to
assist.
page
Page
47.
Page?
Page 47. Last 3 lines.
Last 3 lines.
Now, the last contention of the Housing Board in reply to the submission that the petitioner was never informed and no notice was served upon the allottee about the cost of the flat, which has been increased after payment of installment. The submission was made that decision was taken in 181st meeting held on 30th of April 1998, which was notified in the form of office order on the notice board of the Housing Board. The notices were published in the newspaper calling upon the allottees to get their accounts verified by the board by producing the money receipts issued in their favor. The petitioner has annexed Annexure 10 in reply to the notice dated 27/6/2013, where he has not raised the plea that petitioner was not informed as being raised in the present writ petition. In the preceding paragraphs of the order, I have indicated that the Housing Board was not justified in notifying revised price on notice board after handing over possession of the flat. Similarly, the newspaper publication calling the individual allottees to produce the money receipt is again an eyewash. It was the duty of the Housing Board to maintain record and keep on informing the allottee if there is any default in payment and if there is any increase.
All right, para 29.
My lord.
Now, Annexure 11, what was that?
My Lord will kindly have a look at Annexure 11, which is at page 200, running page 200. I'm sorry, that is not at page.
Running page 200, yes.
89.
That's Annexure 13.
My Lord, page 89, running page 89.
Running page 89, 189.
Just 89, my Lord.
Yes.
उपर्युक्त विषय के संबंध में सूचित करना है कि बहादुरपुर पटना स्थित फ्लैट संख्या 100 जो आपको आवंटित है तथा दिनांक 6/8/97 को इकरारनामा का निबंधन कराया गया है कि विरुद्ध इकरारनामा निष्पादन के पश्चात किस्त की राशि जमा नहीं की गई है, जो निष्पादित इकरारनामा के कंडिका 24C आवंटन आदेश की कंडिका 13 का उल्लंघन है। किस्त की राशि जमा करने हेतु इस कार्यालय में विभिन्न पत्रों एवं निजी संपर्क कर अनुरोध किया गया है, लेकिन इन समारोह एवं व्यक्तिगत संपर्क के बावजूद भी आपके द्वारा बकाया किस्त की राशि जमा नहीं की गई है। अतः आवंटन आदेश एवं इकरारनामा में निहित प्रावधानों के उल्लंघन से आवंटन रद्द किया। दिस इज द ऑर्डर व्हिच इज अंडर चैलेंज।
That's right. How have you disputed this? किस्त की राशि जमा करने हेतु इस कार्यालय के विभिन्न पत्रों एवं निजी संपर्क का अनुरोध किया। विभिन्न पत्र, no letter has been produced by the board.
My Lord.
Any letter intimated?
My Lord,
intimating you.
If my Lord will kindly have a look at page 203 and page 204, which is Annexure 14 and 15.
Yes.
This was that letter, my Lord, by which they had said that we had made paper publications.
Paper publication and pasting it on the
My lord.
notice board,
My
all
lord.
right.
My lord.
That the court has taken exception, it could not have been done.
My Lord. So this
Now,
was the letter
letters,
that
this is
this
the letter,
was the
sent-
letter that they issued, Annexure 14 at page 203, my Lord, wherein they said ki you come over and get your accounts verified. This is the amount that is due to you. So in response thereto, Mathuranath Roy had gone and met the executive engineer who had issued that letter, and they issued this letter, Annexure 15, which is at page 204. My Lord will kindly have a look at the bottom of the page. This is dated 6/5/2006, giving a reference to the original letter, my Lord. प्रतिलिपि श्री मथुरानाथ रॉय मध्यम आय स्वयं से पटना को सूचनार्थ प्रेषित इकरारनामा के अनुसार सितंबर 97 से 180 मासिक किस्तों में शेष राशि का भुगतान करना है। अतः इस कार्यालय के पत्रांक 4/5/2006 द्वारा निर्गत मांग सूचना वापस लिया जाता है। आप मासिक किस्तों का भुगतान यथावत करते रहें।
ये कहाँ
And
पर
there
रहा
are-
Annexure 15 at
So
page
even
204? एक
as
second.
I'm sorry, my Lord.
कहाँ आपने पढ़ा? पेज 204 पर हमें
Bottom of it, my Lord, just below the letter number and the date.
yes,
my Lord.
yes, below the letter number.
So
Firstly-
they withdrew that letter 20, which had been issued on 4/5/2006 by this letter, which was issued on 6/5/2006, and I was directed to continue paying as in terms of whatever had been decided by the original letter. And then the original letter itself said that the last paragraph it, अतः अनुरोध है कि अपने स्तर से माननीय उच्च न्यायालय के आदेश के तहत जांच कर संशोधित बकाया सूचना निर्गत करने की कार्रवाई करना चाहेंगे। the last paragraph of the substantive
this is
letter
this is a letter sent by executive engineer to Rajaswa Padadhikari
of the
Aabas
housing board. So this was the original letter that had been issued by the executive engineer himself of the housing board. Then he withdrew this letter saying that there is no other dues, that you continue paying in terms of the original installments. So the original installment was 793, 181 installments we paid.
Where has the single judge dealt with it?
With regard to the paragraph that I read out, my lord,
Therefore, the demand was not pursued.
This demand was not pursued. It was only thereafter, my lord, in the year 2013 that they issued that letter, Annexure 11, by which they said that this is the amount that is due as against you because you have not paid the installments. Now, at no point of time
when did you respond? Why did you not respond after Annexure 11?
My lord,
That this was the instruction to you not to pay anything except what was being paid by
my lord,
you.
that discussion is also there. My lord will kindly
Where has
just place the letter.
Where has the single judge dealt with it? That's an important piece of fact.
That the entire amount of the installments had already been paid by us.
Where has the single judge dealt with these two letters and Annexure 1? The single judge has quashed Annexure 1,
My lord,
Annexure 11.
Annexure 11.
Annexure 11
My lord.
must have relied upon Annexure 15. Must have relied upon Annexure 15. Where is the discussion?
My lord.
No, you're proceeding on
that
the right
discussion,
lines.
my lord, he has taken note of during while recording this fact that these are the submissions of the petition.
He must have dealt with it. No, for quashing
My lord.
for quashing Annexure 11,
My lord,
the court perhaps what you have made
my
us
lord,
read.
there are two issues that this honorable court had dealt with. One was with regard to this fact that no notice was issued to him with regard to the installments. That was one aspect of it.
No, so that appears to be incorrect because there was a notice by way of Annexure 14.
My lord.
Right?
My lord,
So
but
that
none of them
notice
say-
stands liquidated, that notice stands withdrawn with Annexure 15.
My lord.
The footnote.
My lord.
Not the Annexure 15 was not addressed to you, but the copy which was marked to you, there you were not asked to make any further payment. Therefore, that notice appears to have been rescinded.
My lord.
So therefore, where has the court said that in view of Annexure 15, the stand of the board is incorrect, that there was any attempt to notice
lord.
the allottee? I think this way the matter would it will be shorter and easier to handle.
Your Lordship, may I submit?
We will hear from you. It's your appeal. We'll hear from you, but since they are taking advantage of the order, let us hear from them first. This is not the correct procedure, but for some reason or the other, I have asked him to. Where has the court dealt with it?
I'll come to that. My lord, probably the honorable single judge has not been, he has not dealt with those two particular letters, my lord.
Yes.
Those two letters have not been dealt with. They have, the honorable single judge has dealt with the letter that was issued in the month of December 2007.
No.
Which
Now
is at page 38.
You perhaps today would rely on Annexure 15.
My lord,
For
14 and
justification.
15. And then, my lord, even otherwise, what they are relying upon is Annexure C to their counter affidavit, which is this letter dated 20th of December 2007, which came to us after almost 10 years. And this was in the year 1998 that they had fixed the price as 3,58,000, and they issued this letter to me, which we have said that we have not received, even assuming that this letter had been sent and had been received by us. Our contention was that it came to us almost 10 years after that they had decided that the prices have to go up. Now they have calculated the interest right from the period 1984 till 1998 and thereafter till 2007 and then till 2013. So what we were saying is that at any point of time, if they would have brought it to the notice of this honorable court, even during the course of the original writ application, 3924, 1996, there was no disclosure with regard to enhancement of the price, because then they were saying that current price has to be paid. So they had a calculation with regard to the current price.
So that is something which you expected as a sequel to this to the discussion. But now come to para 30. Para 30 of the judgment.
My lord. It
Read.
is significant to note that the tentative
No,
price.
however, quashing of Annexure 11,
My lord.
para 30, I think the numbering would be the
30.
same in your order.
I was looking at 13, my lord. I'm sorry.
30.
I'm sorry, my lord. Quashing of Annexure 11 will not entitle the Housing Board to realize the amount, if any, payable by the petitioner against the delayed payment of installments. The Housing Board shall work out the details of the delayed payment and penalty for delayed payment and raise a demand for payment of the aforesaid amount within a period of 60 days. In addition thereto, the Housing Board may be justified in raising the difference of the amount already paid and the actual amount in construction of the flat which has been worked out by the House Board in a 181 installment, which has been highlighted in the counter affidavit as tentative price. The difference of the amount fixed at the time of handing over possession and the amount determined in 181st meeting shall be worked out by the respondent within a period of 60 days. And the difference between the amount of tentative price already paid and the price which was worked out in the 181st meeting shall be raised by the Housing Board within the aforesaid period, and thereafter within 60 days from raising such demand,
That's
the
right.
petitioner
So
shall
that's,
pay that
that's
amount.
right. We have followed that. Now, therefore, the court does not say that the board would not be entitled to calculate and saddle upon you the delayed payment interest, right? So, from which period to which period would it be calculated was the only issue left open to the board.
My lord, as we understood the order of the Honorable Court was that they were supposed to calculate 3,50,000 as they had decided in the meeting that they held on April 1998. So that came to 3,58,000. Now, as against the installments, if we have failed in paying the installment, they are entitled to a penalty thereon. Now, they have given a calculation
So,
chart.
from which date?
My lord,
From
So-
which date?
the dispute was what they were saying, my lord,
Right from the beginning.
right from the beginning.
That was unjustified.
Their basic
prima facie, but then
Their
thereafter-
basic contention was that why I have defaulted in payment of the no, I'm just trying to explain as to why this this writ application and this LPA had come into being. My lord. Their contention was we have calculated that 16 lakh amount or 3,58,000 was the price. Now, based thereon that you were supposed to pay the installments. But the fact remained that in the year 1984, the installment that had been fixed was 793 based on the price they had calculated in the year 1984,
When the
which
house
came
was-
to 80,000.
when the house was already constructed.
87, there is a letter to that effect, my lord, at page 200, saying that that house is already constructed, water supplies have already been given, now you move into it, take possession of it. So that is 87. Their contention is that we have already enhanced the price, you have not paid the enhanced installment.
So the court has not agreed that part of the.
So penalty amount, we are agreeable to it based on whatever the installment that we were supposed to pay 793, and they have given a calculation chart, only 9,000 rupees that was due to us, due against us.
After this judgment, they have given you a chart.
No, my lord. Even during the course of this writ application, they have given a chart which is part of the counter affidavit saying 9,398 was what
Which
was
you are
due.
ready to pay.
My lord, that is all that I am supposed to pay, and they have charged an amount of penalty about 14,000 rupees thereon.
Yes, I must say.
Your Lordship, this was a scheme for 288 flats, Your Lordship. So as and when the flats were being constructed, possession was being given. Your Lordship, after the entire completion of the project in the year 1998, the board held a meeting and the cost of each flat came to 3,58,800, Your Lordship. Thereafter, the board, as per the counter affidavit, Your Lordship, we had affixed the amount which was to be payable after deduction of the original amount decided as per the hire purchase agreement, because that was a tentative cost and the final cost was to be ascertained after the completion of the entire scheme, Your Lordship. Thereafter, Your Lordship, there was no payment, but the board brought on record on the query of the Honorable Single Judge the receipt and the registered receipt whereby in 2007 the petitioner had received that now the amount of 6 lakhs was to be paid in view of non-payment of the additional amount. So that after 2007, Your Lordship, this Honorable Court has said that the board has kept silence for 9 years. Our submission in this is in the LPA is that even after 2007, till the cancellation, the petitioner also did not come forward to pay the amount which was decided, or to get it adjudicated, or to understand as to.
We do not appreciate that contention
Okay,
on board.
Your Lordship, so
But
after
this order was-
2007, several reminders were given, and with the enhancement, thereafter, Your Lordship, this Honorable Single Judge has relied on a judgment which is not at all applicable in our case, because in
We are
our
not
case.
cons- we are not, the
Your Lordship.
judgments would not cover the
Your Lordship.
appeal. and-
Your Lordship, then
Now,
Your Lordship.
just a minute.
Ji.
Now, how do you justify, and what is your answer to this letter dated 6/5/2006 contained in Annexure 15 for you to agitate now after the judgment of
Your
the
Lordship, that letter was not correct, because thereafter in 2007 we did, that was in 2006, that thereafter the board informed that in 2007 that an amount of 6 lakhs and odds have to be paid with
Where is
respect.
that correspondence? Where is the evidence that it was the allotee was put to notice?
Your Lordship, that is annexure,
Anyway, what
that is there, Your Lordship, annexure L to the fourth
now-
supplementary affidavit.
Now, what is expected of you to?
Receipt
answer
of
this?
registered
Just a
post is
minute.
also annexed.
Now,
Your
give us a 2 pages fact sheet giving the stages at which you gave a notice of the escalation of the escalated price. They did not respond, and similarly, Mr. Mrigank Molly, you would also give a 2
Well,
page,
we'll
3
do that.
pages fact sheet for orders. We keep it for orders on Wednesday.
Lordship, it may come on Monday, Lordship.
You're ready with the brief? What is the matter? We will.
Wednesday is
You just
tomorrow,
need to
Your
give a 3 pages fact sheet.
My lord,
Both
we'll
of
do
you?
that. In fact, my lord, during the course of the writ application, both the parties had filed their written submissions. Or probably that would be. in the-
That's a stale one. Now, after this judgment, give us a fact sheet of 3
My lord, we'll
pages.
do that.
We give you
My lord will give us some more time than that.
some more time. So we are fixing it on Monday for orders.
Much
Or under the same
much
heading.
obliged. Much-
But you give the fact sheet latest by Friday,
My lord, we'll do that.
Online.
right?
Online, no.
Online.
Your Lordship, because that day the court would not be there. Oh, we'll
Friday
send
you
it.
give it to my court, both of
Ji.
you would give it to my
Courtmaster. We'll do that.
courtmaster.
Obliged.
They are not keeping it online.
Nahi, we'll come and give.
Or if you can do that early, you can file
We'll
it
do that,
online.
ma'am.
We will have it down.
As early as possible, we'll try and do that.
Friday. It
My
should be before Monday.
My lord, we'll do that.
Your Lordship, only the stages on which notices were given to the petitioner for the, Your Lordship.
Again,
Obliged.
the learned counsel for the parties have been requested by the bench to provide a fact sheet in short indicating the stages at which notices were sent to the allotee / the respondent, and the evidence in support of such notice having been received by the respondent. Mr. Mrigank Molly, learned counsel for the respondent, would furnish would furnish the stand of the allotee with respect to the receipt of the notice. Re-notify on Monday. Under
4th of July.
Obliged.
We have only asked for a small thing, but you have to give the fact sheet of the entire case.
My lord.
And it must be referable to the facts stated in the order.
My lord. And the running pages. My
You know how the fact sheet is to be prepared.
We'll do that.
What is the case in one paragraph, and thereafter where is the decision, where this point has been dealt with by the London single judge, what are the materials, annexures, corresponding references.
My lord, we'll-
You need not write it,
My
but
lord.
corresponding references with the page number.
Obliged.